Is there a fundamental right to drink or consume alcohol? The arguments in favor of alcohol were multiple. That the state should not be paternalistic in its attitude, that this republic without a pub will be a relic. The state financially benefits from the sale of alcohol because the excise duty and the license fee it collects from the sale of alcohol fills the state's coffers. The question therefore boils down to whether the state can infringe upon the rights of individuals to choose to consume alcohol and decide the way of life for themselves. However, in the realm of constitutional law, none of these rights are available to an entity desirous of doing business related to alcohol. Do alcohol manufacturers have the right to trade? How do courts of law deal with this perplexed question, and what answers have the courts provided over the years? Ban on alcohol must be seen from the perspective of three stakeholders. Alcohol ban in India. Let's consider the legality and history. Human consumption of alcohol has always been considered as a vice and not a virtue across multiple cultures. Whether it is the Occidental abstinence movement or the Oriental moral compass, alcohol consumption by individuals and its regulation by the state has been a widely debated issue in India. About 5 states in India have prohibited alcohol, whilst there are many others which have partially controlled alcohol consumption. Ironically, there are many states in India whose prime revenue comes from excise duty, majorly earned from liquor sales. Ban on alcohol must be seen from the perspective of three stakeholders. 1. The people involved in the trade and business of alcohol. 2. The state itself. And 3. The citizens. And of course, these three are intrinsically linked to each other. The state financially benefits from the sale of alcohol because the excise duty and the license fee it collects from the sale of alcohol fills the state's coffers. The vendors or other businessmen who trade in alcohol earn money whilst the citizens consume the product. The state and the businesses benefit financially from the sale of alcohol, but the argument against the sale of alcohol or in favor of the ban is primarily pivoted around the adverse effects on public health. The question therefore boils down to whether the state can infringe upon the rights of individuals to choose to consume alcohol and decide the way of life for themselves. After all, in a liberal constitutional democracy, one must be free to entertain oneself with all permissible pleasures. Should it then be that after setting a threshold of minimum age, for example, it must be completely left to the individual to decide their own lifestyle? Do alcohol manufacturers have the right to trade? How do courts of law deal with this perplexed question, and what answers have the courts provided over the years? The question on whether alcohol manufacturers have a right to trade is a question of constitutional significance. Article 19(1)(g) of the Constitution of India provides for the fundamental right to practice any profession, to carry on any occupation, or to conduct any trade or business. Similarly, Article 301 of the Constitution also provides for the freedom of trade and commerce as a constitutional right. However, in the realm of constitutional law, none of these rights are available to an entity desirous of doing business related to alcohol. The Supreme Court of India, in the celebrated coded distillery case, clarified that trade and business related to alcohol is res extra commercium. That is, it's outside the commerce, and therefore it is not a right available either under Article 19(1)(g) or under Article 301 of the Constitution for an individual or an entity to trade in alcohol. Now, while saying so, the court placed emphasis on Article 47 of the Constitution, under which the state is expected to raise the level of nutrition and the standard of living and to improve public health, and also prohibit the consumption of drugs and intoxicating drinks which are injurious to health. And now that takes us to another point. Is there a fundamental right to drink or consume alcohol? Human life has its charm, and there is no reason why life should not be enjoyed along with all permissible pleasures. The right to life under Article 21 of the Constitution is often traced in order to mount a case against the complete ban of alcohol. Although the right to life is increasingly interpreted liberally, the question regarding the right to consume alcohol arose before the Supreme Court of India in multiple cases, starting from the leading case of Bombay versus FN Balsara. The arguments in favor of alcohol were multiple: that the state should not be paternalistic in its attitude, that this republic without a pub will be a relic. The top court held that restrictions that had been imposed under the Bombay Prohibition Act of 1949 that banned the consumption of alcohol does not infringe the fundamental rights of the citizens. The courts in India have consistently held that one cannot assert a fundamental right to consume alcohol, but the broad stroke approach and expansive reading of the right to life under Article 21 of the Constitution and the interpretation of it to include the right to privacy and the right to personal autonomy by a 9-judge bench of the Supreme Court in the case of Justice Puttaswamy versus Union of India has rekindled the argument against restricting the citizen from indulging in pleasures permissible in a completely libertarian society. The rights and obligations of the state under the Constitution is multiple. Under our Constitution, India is a welfare state, that is, a state which plays a key role in the protection and promotion of the economic and social well-being of its citizens. The Constitution ensures that India is a welfare state by virtue of the mandates in Part 4 of the Constitution. They contain the directive principles of state policy. Article 37 of the Constitution makes Part 4, that is the directive principles of state policy, unenforceable by a court of law. However, it continues to hold that these principles are fundamental in the governance of the country. Article 37 therefore casts a duty on the state to apply these principles in the process of lawmaking. Now, within the directive principles of state policy, under Article 47 of the Constitution, the state is duty bound to ensure raising level of nutrition and the standard of living of its people and the improvement of public health. Furthermore, the state shall endeavor to bring about prohibition of the consumption, except for medicinal purposes, of intoxicating drinks and drugs which are injurious to health. Now, in the constitutional scheme, state legislatures are empowered to make laws relating to the production, manufacture, processing, transport, purchase and sale of intoxicating liquors. Therefore, when several states have chosen to maximize revenue from these activities by way of auctioning and tendering businesses related to alcohol, several other states have chosen to ban alcohol for personal consumption. There are several states who have chosen to keep some part of the supply chain of alcohol with themselves, in most cases, usually sales of alcohol. Courts have relied upon Article 47 of the Constitution while dealing with the challenge relating to ban of alcohol. Article 47 ordains the legislature to regard as its duty raising the people's level of nutrition and public health, while stating in general the provision particularizes one solemn obligation. The state will endeavor to prohibit the consumption, except for medicinal purposes, of intoxicating drinks and drugs which are injurious to health. Nutrition and public health are two of the numerous facets of bettering the living standards. To achieve this objective, the state may adopt varied methods, but the Constitution pins the state to one particular method besides all others: prohibit the consumption of intoxicating drinks and also drugs which are harmful to health. Categoric is the constitutional mandate that the endeavor is towards prohibiting consumption of intoxicating drinks. Regulating the manufacture and sale of liquor are just intermediary steps, collateral or contributory to achieving the main objective, that is prohibiting the consumption of alcohol. Of the two evils mentioned in Article 47, intoxicating drinks as a whole faces the axe, while only those drugs which are harmful to health gets outlawed. For drugs is employed generically and followed by the relative qualifier harmful to health. The Constitution therefore presumes that any drink intoxicating is harmful. In other words, intoxicating drinks does not get qualified by harmful to health. In fact, alcohol ban was also considered in detail by the framers of the Constitution. The draft Article 38, which is the present Article 47, was debated on the 23rd and 24th of November 1948 in the Constituent Assembly of India. It imposed an obligation on the state to improve public health, nutrition and the standards of living. A member of the Constituent Assembly, Mahavir Tyagi, moved an amendment to the draft Article 38 to include the words "and shall endeavor to bring about the prohibition of the consumption of intoxicating drinks and drugs which are injurious to health. However, another member of the Constituent Assembly, B.H. Kardekar, offered several arguments against the adoption of the two amendments that were proposed. He opposed it on three grounds. First, prohibition was hard to enforce. Second, even limited enforcement would overwhelm the jails in the country. And the third, the revenue loss would be substantial. He argued that similar prohibitions, both in America and in pre-independent India, that is Madras, had proven unsuccessful and expensive. Many people continued to consume alcohol whilst the state incurred extra costs to keep in jail those people who broke the ban. Moreover, he contended that prohibition infringed on personal liberty of citizens. But history had it otherwise, and Article 47 did come into our constitution. India has a long history of banning alcohol, with the prohibition part of the directive principles of state policy on the one hand and also adopting the Gandhian principles on the other. Mahatma Gandhi wrote, "Alcohol makes a man forget himself, and while its effects last, he becomes utterly incapable of doing anything useful. Those who take to drinking," he said, "ruin themselves and ruin their people." Currently, there are 5 states with almost total prohibition and much more with partial prohibition. They include Bihar, Gujarat, Lakshadweep, Mizoram and Nagaland. As regards alcohol ban, experience from the rest of the world has been mixed. Most countries that introduced prohibition have either withdrawn or liberalized the measure, like for example, the United States of America, Japan and even China. At present, there is complete prohibition of liquor in multiple countries in the Middle East, North Africa and even some Asian countries, including for example, Afghanistan, Libya, Saudi Arabia, Somalia, Sudan. Some of the other countries like Brunei, Comoro, Iran, Kuwait, Maldives, Mauritania and even Pakistan, Syria, Yemen prohibit alcohol for Muslim citizens only. The United Arab Emirates allows for some sale of alcohol except in the region of Sharjah. What are the long-term effects of alcohol ban on public health and economy? Here is an example what a complete ban on alcohol can achieve in the Indian experience. After about 8 years since alcohol was banned in Bihar, which is home to a little more than 1% of the world's population, a study was conducted in May 2024 on a quasi-experimental population, and the study was published in Lancet. The researchers found that the ban led to reduced frequent alcohol consumption, it lowered the overweight and obesity amongst males, and reduced experiences of emotional and sexual violence amongst females. The ban prevented approximately 2.4 million cases of daily or weekly alcohol consumption and 1.8 million cases of overweight or obesity amongst males and 2.1 million cases of intimate partner violence amongst females. The report concluded, therefore, that strict alcohol regulation policies may yield significant population level health benefits for frequent drinkers and many victims of intimate partner violence. In a study titled "Health and Social Burden of Alcohol Use Disorders in an Industrial Population of India," published in April 23 by the International Journal of Community Medicine and Public Health, showed that a gain in GDP from taxation or sale of alcohol is at the cost of the country's health. The report estimates that the economic burden of alcohol consumption in India on the health system is approximately $48 billion, whereas the societal burden, which includes health cost, productivity loss and so on, is at a staggering $1.8 trillion. 15 to 20% of the work absenteeism and 40% of the accidents at the workplace in India are attributed to alcohol consumption, entailing an annual loss of about 70,000 to 80,000 million rupees. Clearly, there is positive attributes to banning alcohol.